Intracorporate controversy.
What is an intracorporate controversy? How do we determine whether a case involves an intracorporate controversy? An intracorporate controversy is one which pertains to any of the following relationships. Number one, between the corporation, partnership, or association and the public. Number two, between the corporation, partnership, or association and the state, insofar as its franchise, permit, or license to operate is concerned. Number three, between the corporation, partnership, or association and its stockholders, partners, or associates themselves. And number four, among the stockholders, partners, or associates themselves. There are two tests that we can use to determine whether a dispute constitutes an intracorporate controversy, either the relationship test or the nature of controversy test. Under the relationship test, the consideration in determining whether a dispute constitutes an intracorporate controversy is the existence of the following types of relationships or intracorporate relations. Under relationship test, the existence of the above intracorporate relations makes the case intracorporate. However, under the nature of controversy test, the incidence of the intracorporate relationship must also be considered for the purpose of ascertaining whether the controversy itself is intracorporate. The controversy must not only be rooted in the existence of an intracorporate relationship, but must as well pertain to the enforcement of the parties' correlative rights and obligations under the Corporation Code and the internal and intracorporate regulatory rules of the corporation. If the relationship and its incidents are merely incidental to the controversy, or if there will be conflict even if the relationship does not exist, then no intracorporate controversy exists. Under the nature of controversy test, the controversy must not only be rooted in the existence of an intracorporate relationship, but must as well pertain to the enforcement of the parties' correlative rights and obligations under the Corporation Code. Let us have this problem. Spouses Moreno are the registered owner of a penthouse and two parking slots in Chateau Bebe Condominium Corporation who obtain a loan secured by the said properties. The spouses failed to pay their association dues, prompting the condominium association to enforce its lien in an extrajudicial foreclosure sale pursuant to RA 4726. This is the Condominium Act. And the properties were sold to the condominium association as the loan bidder. However, it was questioned by the creditor mortgagee. While the case questioning the validity of the foreclosure sale was pending, the spouses filed a case before the RTC questioning the computation of the dues assessed to them and asked for an accounting of the said unpaid dues. The condominium association, however, questioned the complaint because the spouses are guilty of forum shopping, litispendencia, etc. Will the complaint for intracorporate dispute prosper? Now, how do we answer this? Would the complaint prosper? Yes. The question before the RTC involved an intracorporate dispute. The spouses were asking for an accounting of the association dues and were questioning the manner of calculation of the dues assessed against them. These issues are alien to the first case that was initiated by the creditor mortgagee, that is to stop the extrajudicial sale on the basis of the lack of the requirements for a valid foreclosure sale. Just because the property has already been sold extrajudicially does not mean that the question assessments have now become legal and valid or that they have become immaterial. In fact, the validity of the foreclosure sale depends on the legality of the assessments, and the issue must be determined by the SEC, if only to ensure that the private respondent was not deprived of her property without having been heard.
Jurisdiction on cases involving intracorporate controversy has been transferred already from the Securities and Exchange Commission to the specialized regional trial courts. This is pursuant to Republic Act 8799 or the Securities and Regulations Code. What is a derivative suit? A derivative suit is an action brought by a stockholder on behalf of the corporation to enforce corporate rights against the corporation's directors, officers, or other insiders. This is a suit filed by a stockholder in the name and in behalf of the corporation to protect corporate rights or redress wrongs committed against the corporation. Whenever corporate officers refuse to bring such actions, or such officers are the ones to be sued or held liable. In such action, the suing stockholder is regarded as a nominal party, with the corporation as the real party in interest. Requisites for the filing of a derivative suit. Number 1. The party bringing the suit should be a shareholder as of the time of the act or transaction complained of. Number 2. He has exhausted intracorporate remedies. And number 3. The cause of action actually devolves on the corporation, the wrongdoing or harm having been caused to the corporation and not to the particular stockholder bringing the suit. Distinguish derivative suit from representative suit or individual suit. In a derivative suit, the wrong sought to be redressed is committed against the corporation itself. In a representative suit, the cause of action is a wrong committed against a group of stockholders, as where preferred stockholders' rights are violated, or where a group of stockholders is denied the right to receive dividends or to vote in certain stockholders' meetings. In an individual or personal suit, the wrong affects only a particular stockholder, such as when he is denied the right to inspect corporate books and he institutes the suit in his own name to enforce his own personal right. Appraisal right. Any stockholder who dissented from or voted against the proposed corporate action can exercise his appraisal right. This is the right granted under the law to any shareholder to demand payment of his shares, but only limited to those instances allowed under Section 80. When can the stockholders' appraisal right be exercised? In 4 instances. Our code for this is MISA. M. Merger or consolidation. I. Investment of corporate funds for any purpose other than the primary purpose of the corporation. S. Sale, lease, exchange, transfer, mortgage, pledge, or other disposition of all or substantially all of the corporate property and assets. Or A. Amendment to the Articles of Incorporation which has the effect of changing or restricting the rights of any stockholder or class of shares or of authorizing preferences in any respect superior to those of outstanding shares of any class, or of extending or shortening the term of corporate existence. Remember, under Section 80, these are the instances that The right of appraisal can be exercised by a stockholder.
How appraisal right is exercised? The stockholder submits his written demand on the corporation within 30 days after the date on which the vote was taken for the payment of the fair value of his shares. Failure to make such demand within the said period shall be deemed a waiver of the appraisal right. Within 10 days after demanding payment for his shares, the dissenting stockholder shall submit the certificate of stock representing his shares to the corporation for appropriate notation. His failure to do so shall, at the option of the corporation, terminate his appraisal right. If the proposed corporate action is implemented or effected, the corporation shall pay to the stockholder the fair value of the shares within 30 days from the time such fair value is determined, and upon surrender of the certificates of stock representing his shares. The dissenting stockholder shall be paid the fair value of his shares as of the day prior to the date on which the vote was taken, excluding any appreciation or depreciation in anticipation of such corporate action. However, if within a period of 60 days from the time the proposed corporate action was approved, the withdrawing stockholder and the corporation cannot agree on the fair value of the shares, it shall be determined and appraised by 3 disinterested persons, one of whom shall be named by the stockholder, another by the corporation, and the third by the 2 thus chosen. The findings of the majority of the appraisers shall be final, and their award shall be paid by the corporation within 30 days after such award is made. If the dissenting stockholder is not paid within 30 days after the award, his voting and dividend rights shall be restored.
No payment shall be made to any dissenting stockholder unless the corporation has unrestricted retained earnings. As a rule, the expenses of appraisal shall be borne by the corporation. Upon payment, the stockholder shall transfer his shares to the corporation, and all rights accruing to such shares, including voting and dividend rights, shall be suspended.
Problem. Julio is a stockholder and director of GCA. During the meeting of the stockholders for the issuance of stock dividends, he vehemently dissent to stock issuance since he is in dire necessity and demanded for cash dividends. Since majority of the board of directors and almost 75% of the stockholders voted for issuance of stock dividends, out of anger, Julio demanded for the payment of his shares. He immediately exercised his appraisal right but was refused by the board. Can Julio demand payment of the fair value of his shares? Remember there are only instances provided for in Section 18 that a stockholder can exercise his right of appraisal. Our code is MISA, merger, consolidation, investment of corporate funds in another corporation or business other than the purpose of the corporation, in case of sale, lease, exchange, mortgage, or disposition of all or substantially all of corporate property, and in case of amendment of the articles of incorporation, giving certain preferences to particular class of stockholder or restricting the rights of another class of stockholder, or in extension or shortening of corporate term. We are only but have few limited instances. Issuance of stock dividend is not included no, in those cases that a stockholder can exercise his appraisal right. Therefore, Julio cannot demand payment of the fair value of his shares because appraisal right is not an absolute right. Problem. Ben is a stockholder of Ben & Ben Corporation. Due to financial reverses, the board of directors decided to consolidate the corporation with Speedwagon Inc. to maximize the resources. Ben refused the decision and within 5 days filed his formal demand letter claiming for the fair value of his shares. At that time, Ben & Ben Corporation does not have sufficient funds from its retained earnings, whether restricted or not. Nonetheless, Ben & Ben Corporation paid Ben shares of stock. Subsequently, a derivative suit was filed by another stockholder against those who allowed the payment of Ben's shares. Would this suit prosper? In the exercise of appraisal right, the corporation should always consider the existence of unrestricted retained earnings. The corporation cannot reacquire its own shares, absence of unrestricted retained earnings, because that will be violative of the trust fund doctrine. Except in 2 cases. Remember what we have discussed? In the purchase of redeemable shares under Section 8, and in case, upon order of the SEC, to break the deadlock under Section 104. But in the rest of the cases and situations, the corporation can only reacquire its own shares if there exist unrestricted retained earnings. Therefore, the derivative suit filed by the stockholder will prosper.
That's how we'll always be, inseparable. Just you and me. It's so wonderful to know you'll always be around me. What you are to me, incredible. You bring out the woman in me with your silent love, inseparable. Yes, we are. We're like a flower to a tree, like words to a melody of love. There's no way we can break up, no words that can take us below a thing. We're just inseparable. That's how it is, inseparable. For the rest of our years, it's so